judgment room.
We will go on the record in the matter 26 CF43, State of Wisconsin versus Alicia Rosland. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Rosland in person with counsel Eugene Harrington. We're set today in this matter for preliminary hearing. It will proceed. Please call your first witness, Mr. Schmidt.
I call Andrew Tyler.
Officer Tyler, please come forward. You're going to raise your right hand. You'll be sworn in, then come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I swear.
All right, you may begin.
Can you state your name for the record?
Andrew Tyler.
What do you do for a living?
I'm a police officer for the Village of Siren.
How long have you been so employed?
Been employed there since August of 2025.
Did you respond to a call of a disturbance on March 21st, 2026 around 2:50 a.m.
Yes.
In Maple Lane in the Village of Siren?
Yes.
Did you go out there?
Yes.
Where did you go and what'd you see?
Went into the house. When I entered the house, I met the victim and she brought me downstairs. When I went downstairs, I met the two suspects and three victims at that time.
Before we get into that, the residence you went to, is it in Burnett County?
Yes.
Okay. So you made contact with a number of people. What'd they say?
When I entered, the victim was upstairs. Initials DO was upstairs. She said they were downstairs. When I went downstairs, I was able to separate the two suspects from the victims, and they went upstairs. And I spoke with the two victims that were downstairs.
Who were they and what did they say?
Initials were JT and DO. Said they were downstairs in the room when the suspects entered the house, went downstairs, entered their bedroom, and attacked them.
You said suspects. Did they know who attacked them?
Yes, it was Alicia and Rhea.
They specified it was those two.
Yes.
You actually saw the Alicia who was there?
Yes, she was in the basement when I entered the house.
Do you see that person in court here today?
Yes, she's seated next to the defense counsel in a black sweatshirt.
Let the record reflect that Officer Tyler has identified Alicia Rosland.
Did DO or JT describe the circumstances leading up to them being attacked?
Yes, they said they were in their room.
Object to the form of the question. We need to know who said what, whether it was JT or DO. Which person said what?
I get the whole victim's rights and Marcy's law, but we don't have to use initials. This is a formal hearing. Please use the names. All right, so that is sustained.
Who did you talk to?
We talked to Jack Taylor and Desiree Otto.
Did any of them say how the circumstances led up to the attack?
Yes.
Who and what did they say?
They both said that.
That's the form. There has to be a specific identifying who's speaking.
That's why I said who and what did they say?
And that's a compound
The
question.
compound question sustained.
Who did you talk? Okay. What did Desiree say?
Desiree said she was in her bedroom and the two suspects entered the house, went down to the bedroom, entered the bedroom and attacked her and Jack.
What did Jack say?
He said that he was in the bedroom and they came in and attacked him in the bedroom.
Did Desiree give any more details about how the attack went?
At that time, she said that later on, she did give more details. Do you want me to go into what was said later on?
Yes.
Okay. Yeah, she said that when they entered the room, that she was grabbed by her hair, this would have been by Rhea, and then shoved to the ground and then kicked on the side and the head approximately 20 times. And when she was grabbed by her hair, it ripped some of her hair out.
And did she say where this occurred in the house?
It occurred in her bedroom in the basement.
Okay. Same question for Mr. Taylor. Did he give further explanation of the circumstances of him being attacked?
He did. He did not know the suspects at the time. He said that one female entered and attacked him. And he said that the other one began attacking Desiree.
Were there any recordings of the incident that you reviewed?
Yes, there was. Lisa, the homeowner, Desiree had called Lisa and left a voicemail. And in that voicemail, you could hear female, presumed to be Desiree, screaming. You could hear and you could hear a female voice saying, "Go, Rhea, for your grandpa," and saying "go" multiple times.
Was there any explanation given of what the connection of Alicia Rosland and Rhea Shabash was to this residence of the people there?
Yeah, so Rhea was a foster child of the owner of the house. She had been there approximately, I believe it was till she was 6 years old.
That was quite a long time ago.
Yes.
And did the owner of the house indicate whether they had permission to come in?
Yes, she said they had no right to be there.
Okay. Did you talk at all to either Rhea or Alicia?
Yes.
What did Rhea say about the incident?
Rhea said that there was a conflict at a bar in town. She said that she had went to the house to confront Desiree. She said that Rhea said that it was her grandpa's house. So she entered the house, went downstairs to the basement. She said that they met her by the bathroom, Desiree, and then she did not know what happened after that. It moved to the bedroom and she did not know.
What did Alicia say?
Alicia said that she said that it was Rhea's house, and that I'd have to reference the report to see exactly what she had said for entering the house.
Refresh your recollection if you reviewed the criminal complaint.
Yeah.
Got it.
Okay. So
Jackson, I want to know what page
okay.
he reviewed first, Judge, and then not to read the page, but what did he review?
What
Okay.
pages have you reviewed, or did you review the entire criminal complaint?
I reviewed pages 1 through 4 up to 4 of 8 to read.
Please put the document down or
okay.
give it back to Mr. Schmidt, and then
Okay.
he may answer the question.
So specifically, Alicia, when asked what had happened, she kind of chuckled, looked at Rhea and said, "How do I explain this?" Or "How do we explain this?"
Is that all she ever said?
She mentioned that it was Rhea's house and that's why they went there.
Okay. Did you ask either I guess I should say the flame, either Jack or Desiree if the attack caused them injury or
Yes.
pain?
Yes.
What'd they say?
Yes, they both confirmed that it did. Talked to Jack later, and he confirmed that it did. I reviewed body camera and observed Desiree had wincing in pain when her head was touched. And then she said she did have EMS. She did get looked at by EMS at that time.
Were there visible injury to her?
Yeah, she had a small cut on the back of her head, blood behind her ear, and she said she could taste blood.
Did she indicate whether she gave consent to being attacked?
She said she did not.
How about the same question for Jack?
He said he did not.
When Rhea was explaining that she went over there about something at the Pheasant Inn, was she saying that happened the same day?
Yes. Yeah, she said it was approximately 10 minutes earlier.
Okay. I don't recall if I asked this, so if I'm repeating it, just let me know. You identified who the homeowner was?
Yes.
Who was that?
Lisa
And did
Taylor.
she say whether Ray and Alicia had permission to enter the residence?
Yes, she said they had no right to be there.
Okay. Did she know Alicia at all?
She knew Rhea through being a foster. I could not recall if she knew Alicia.
And just for clarity, when Desiree was explaining who was attacking her, did she say it was only Rhea or only Alicia or something else?
She said that they had both entered the room and attacked her. Later, she said that it was Rhea that was the one that had pulled her hair down. And she said that Alicia had attacked Jack at that time.
Okay. I have no other questions.
Mr. Harrington.
Thank you, Judge. Did you check the public record to see who actually has title to the real property?
I asked the
Did you
homeowner.
check the
No,
public
I did
record?
not.
There is nothing in your reports or the criminal complaint that indicates that Alicia pulled Desiree's hair, is there?
No.
There's nothing in the criminal complaint to suggest that Desiree kicked, that Alicia kicked Desiree either, is there?
Not in the, no.
And the source for the information that Alicia attacked Jack comes from Jack, correct?
Yes.
Alicia told you that Jack struck her first. Did she not?
I do not recall her telling me that Jack punched her first.
Okay. But you don't recall that.
There-
That's not in the complaint either, is it?
Mhm. No, it's not in the complaint.
Have you talked to, no, I'll withdraw that. Do you know what the disagreement between Alicia and, strike that. Do you know what the disagreement between Rhea and Desiree was about, other than some family thing?
I do not know the specifics. I know that Rhea or Alicia at the time had said that Desiree had said something to her at the bar, called her name.
Thanks. I have no further questions.
Questions? Redirect?
No redirect.
You may step down. Thank you, sir.
Move to dismiss, Judge. There's no, are you done, Kevin? I'm sorry. I jumped the gun here.
Further witnesses?
No other witnesses.
I'll move to dismiss. There's no evidence that they entered this premises without the lawful consent of the owner, because someone else represents that they own the property. Isn't conclusive as a matter of law as to who actually does. Further, there's no evidence that Alicia kicked or stomped or did anything vis-a-vis Desiree or Jack. Jack has an interest in this, and he self-reported that Alicia punched him, and there's no other evidence in the preliminary exam to suggest that that's an accurate recitation of the facts. The state has failed in its burden. Move to dismiss.
Mr. Schmidt?
I think we showed the lawful possession with all reasonable inferences drawn in favor of the state. What needs to be shown for burglary is not title ownership, it's lawful possession. And we've definitely shown that here with the statement from the woman that she's been there for over a decade because she knew Rhea because Rhea lived there as her foster child in 2006, I believe, is what the officer testified to. So she plainly had lawful possession and plainly said these people didn't have consent. In fact, what was described is that a person named Desiree insulted Rhea Shabash, and then Rhea Shabash and her friend went to the house to seek her out to make good on that on their own. I'd also know everything that Attorney Harrington said about who did a battery or not is irrelevant because that's not one of the elements of this offense. The element of burglary with intent to commit battery is whether you have the intent to do it. If a battery actually happens, that's just an enhancer. So I think all reasonable inferences draw in favor of the state. I think one can conclude that these two people, after seeing this insult at a bar, went across the street, went to this house for the purpose of settling up. And even if Mr. Harrington wants to discount that the officer did testify that Desiree said both of them attacked her, which the court should not, this is party to a crime liability. That's shown with like the voicemail showing only other person there who was supportive of Rhea attacking this person could have been Alicia Rosland. That's also reasonable inferences. So I'd ask the court to bind over.
Judge, one comment.
Rebuttal, yes.
There's no identification that the person overheard on the telephone cheerleading, in essence, is actually Alicia.
That's why I said it's a
And
reason.
secondly, Judge, the defendant's not charged with party to the crime. She's charged with actually committing the act. I'll concede that can be solved quickly with the information.
And it can be, and I understand your argument and where you're going, Mr. Harrington. And this is a preliminary hearing and the court has to determine whether there's probable cause to have a felony charged. Defenses are not something that the court can take into play in a preliminary hearing. I can't make any determination of truthfulness of anyone's statements. I can't go to credibility. I can't view the evidence like a jury would. I have to take the statements and the evidence as presented, and it was presented through the testimony of the officer. Cases that have conflicting inferences means the state wins, and there's enough to at least bind it over where a reasonable officer here in training and he reasonably believed that a felony was probably committed and therefore it was charged. In viewing the evidence in the light most favorable to the state, bound over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment or set for another date, Mr. Harrington.
Can we set this for another day simply because it's a technical defect, but I think it has to be charged as a party to the crime. And if Mr. Schmidt is charging these as pled in the information in the complaint, I want to have an opportunity to look at that before I have my client plead. So
Yes, I understand.
another
that.
day, please.
Mr.
Two
Schmidt.
things I'd say to that is if you look at the annotated statute for party to a crime, it says it does not need to be alleged. Also, by having the prelim, you waived any arguments against structural defects.
But here's the thing, this is a discussion that attorneys can have outside of the presence of the courtroom. Therefore, I'm going to set it for another date. You can figure it out. Does May 28th at 9:15 work?
Judge,
Oh, you're fishing.
I'm fishing
Don.
in Canada. I'm sorry. How
Oh,
about
that was my mistake thinking you're only going for a day.
how about June 9th, July 9th at that 10:30? That'll,
Nope, that's way too far. I can do 6/1, June 1st.
I'll
at
be here on
1:45.
another case on June 1st. That'll work.
What time are you here? I didn't look. I don't know what time you're here, but we can figure that.
Mr. Harmon's bail hearing. I think that's it. I left the notice in the truck.
Oh, you are here at 1:30. So June 1st at 1:30, we'll have an arraignment. We can preset that other July date for a status if that's what you would like.
That makes sense, Judge.
Let's preset a status for July 9th at 10:30. July 9th at 10:30. Arraignment will be June 1st.
1:30.
We set a status and an arraignment?
Yeah, just to keep them on the same path, the co-defendants. All right, Ms. Rosland, you can come up here and get your notice and you're free to go.
Thanks for watching, and don't forget to subscribe for more courtroom cases.